SJC-12452, FK, and another VSC.
Thanks, Fran.
Good afternoon, may it please the court. My name is Lisa Kaur, and I represent the defendant appellant, SC, in this matter. And for ease, I may refer to the parties by defendant and plaintiffs to protect their anonymity. On March 16th, the defendant posted an audio recording of a rap song that he performed to SoundCloud, which is a social media music hosting site. The lyrics were vulgar, they were sexually explicit, they were violent. They referenced two fellow students at his high school. He also encouraged, I think the evidence suggests the same day, friends of his through Snapchat to listen to that audio recording. And then on the same day, the evidence is that,
Never mind.
That the two plaintiffs listened to and were seriously alarmed and were placed in fear by that audio recording. On March 28th, there was a full evidentiary hearing, after which the judge issued two harassment prevention orders in favor of each of the plaintiffs. And the judge, in ruling, stated that she was going to consider the individual statements within the song as separate acts, and then also considered evidence that the song was published over two social media websites, and also considered the acts of the defendant in creating, producing, publicizing the song as further evidence of separate acts.
If the person put aside the multiple vulgar threats in the song,
Yes.
right? If this person had put it on SoundCloud,
Yes.
which is the public access to it, right? And then the next day Snapchatted it, and then the next day put it on Twitter, would those be three different acts?
Your Honor, and that's what's addressed, I think, in the single justices. There's a footnote in the single justices decision that says Justice Green didn't conclude that the sort of amplification of the message through Snapchat was a separate act. But even if it were, there are only two acts here.
Right, well, so I guess
So
that's the issue, is publication, because I understand what you're saying about the song being one event,
okay.
and you can't just go through every lyric. But if we say that publishing three different times is a separate act of harassment, going to different audience, going to the intended victims through different media, wouldn't that be harassment?
Your Honor, it could be, but I think the record evidence as to the Snapchat sort of amplification, I'll call it here, was that there were directions to a smaller...
Go on SoundCloud, yeah.
Pardon?
Go to SoundCloud.
Go to SoundCloud. And so it didn't repeat the substance, the harassment. So I suppose there could be circumstances where the harassing communication was repeated, the same communication repeated over three different platforms.
When he put it on SoundCloud, was that also with instructions to listen to it to the intended victims, or
Your Honor,
you had to go to Snapchat for that?
Your Honor, there's no evidence in the record about how that worked. What the evidence was from the testimony of the male plaintiff was that he was advised by several of his friends who had seen the Snapchat message and to go to SoundCloud. And from my understanding, SoundCloud is just a quick review is that it's just a hosting platform where people can go and search for music.
So that's not really publication. Do you think the Snapchat was the publication of it?
I think it's, as Justice Green said, part and parcel of the same harassing conduct. So
but we're talking, I think the question is more about the difference between when you put something on SoundCloud, does it automatically go to somebody? Do you have to tell somebody to go there? How does somebody know something's there?
Your
Or
Honor,
can somebody else see it?
the record isn't,
Hear it?
there isn't any record evidence about how information is publicized from SoundCloud. And I think it's fair to say, though, that it's a public website that I think it may require an account, but that it is out there, and that I think the reasonable inference would be that by publishing it on SoundCloud, that he intended it to be received by whoever could access it. I don't think, there is no record evidence that that until the Snapchat message was viewed by people, there were that people were directed to SoundCloud, but it is accessible, so I think it would qualify as a communication or publication.
But you would agree that if we took the SoundCloud/Snapchat as one publication, if it were done 2 different times on different social media, then that could be a pattern.
I think you would looking at what constitutes an act or a pattern, I took a look at the legislative history and at the case law that interprets the legislative history and the terms as used in the statute. So if you start criminal harassment, harassment protection orders under 258E evolved out of the criminal harassment statute, section 43A, which evolved out of the stalking statute, section 43 of chapter 265.
Wouldn't it be the same if I mail you 3 different letters?
Yes, that would be, if you could
Go
even.
old school, right? If I mail you 3 letters, that could be.
That's 3 acts, because with the act
By
of
post,
mailing
right.
each letter, Your Honor, you have the intent of the actor to put the information in the envelope, seal the envelope, put the stamp on, address it, and send it. And there's an intention to convey that message on each of those.
So 3 separate Snapchats a week apart could be 3 separate acts.
3 separate Snapchats, and Your Honor, I don't use Snapchat, so I'm not quite sure how it works.
Fortunately, my kids do, but.
Okay. And I understand the concern with social media is that it may be out there in perpetuity, and it amplifies the harm to the recipient. But I still think that you need to have, and potentially 3 separate Snapchats that evince the actor's intent to act on each of those separate occasions.
But not this case.
Not this case. Could be Facebook, could be Snapchat, could be Instagram, but you have to have the intent on each of those 3 separate occasions. And I think that the terms that are used in the cases such as incident, that appears in the cases considering criminal harassment under 43A, under stalking. An incident is described as, in Blacks, a discrete occurrence or happening or event, or that is important, or in Webster's, an occurrence or action felt as a separate unit of experience.
So if we go back to the letter analogy, if I wrote a letter that each paragraph had something vile and insulting in it and sent it to you one time, each paragraph is not a separate act.
Correct, Your Honor, because if you follow the district court's reasoning, you could have each sentence, and what if there's no punctuation? I mean, it just lends itself to kind of an unmanageable interpretation of the law.
But if your client had simply written it and done what he should have done, which is
Put it under
put in his
bed.
pocket
Yes.
and then throw it out, there's no act of harassment. It's the publication which is the act of harassment.
There's not, Your Honor. There could have been the most sophisticated sort of production of a song. Until it was publicized, it's not an act of harassment.
So the focus is on the acts of publication in this, with regard to this, not how many verses there are or how many times they make threats to sound like they're gangsters.
Correct, Your Honor. And I was trying to find something in the case law that would support each threat being an act. And I think the closest that I could come was in the context of intimidation of a witness. You could have a single communication, whether it's a letter or a phone call or a face-to-face engagement, and in that single communication, which I would suggest this is, you could have if there were multiple inducements toward witness intimidation, it could support multiple counts of that crime, but that statute is different than this one. It criminalizes the inducement, and here you have a civil statute that goes to the act. And I think the legislative history, and you see the evolution from the Senate bills from 2007 to 2009 to other iterations in 2009 until the statute was enacted, shows that the legislators were concerned with offering protection to a greater number of people than were captured by 209A, but making sure that didn't open the floodgates in the district court. And the appeals court in Gassman recognizes that district courts and municipal courts are busy places, and they often find a range of litigants, whether they're landlord tenants or hockey moms, those sort of things. Still, the judge's inclination in this case may have been appropriate to try to separate the parties to keep the peace, but that inclination to keep the peace is not what the harassment protection order statute is intended to do. There have to be the requisite 3 acts.
But going back to Justice Gaziano's point, if he had written this song and in the old-fashioned way mailed it to the victim directly,
Yes?
and then a week later mailed the same, made a Xerox copy of it, mailed it again a week later, and then mailed it again a week later, you would agree that those are 3 separate acts of communicating a threat to the victim?
I would agree with that, Your Honor. And I would agree that you can even have harassment that's sort of content empty. You could just repeatedly send, if you were establishing a pattern, the content of the letter could even be sort of neutral or appear to sort of the reasonable person as not particularly objectionable. But it's the repeated act that the statute tries to capture. And the reason that you're trying to establish a pattern, I think is evidence in the case law, is that you are although this is not a criminal statute, you're subjecting a person to possible criminal consequences. And the courts have said that the purpose was to cap behavior before it leads to a life-threatening situation, and to prevent further harm. Here, on one act, there's not sufficient evidence of a pattern of behavior. There's one act, as vulgar and violent and upsetting as it was to the students who were the recipients. It's insufficient to support the issuance of a harassment
Is it
prevention
one
order.
continuous act because of the timing of this?
Your Honor,
And it's not the fact that he published it on 2 different websites. If he had posted on 3 different websites, even if he did it at the same time, that would not be a violation of the statute?
Your Honor,
because of the timing of it?
I would suggest that the reasonable inference from the record is that the timing was close in time. It's not clear how different the timing was. But I think that in order for it to be separate acts, there has to be some separation in time. And none of the cases speak to what that time really is. It could occur on the same day, Your Honor. The criminal harassment cases talk about over the period of 35 days or 40 letters or a period of months. I agree that it could be a close period of time, but I think on this record, I'm unable to say how close in time the SoundCloud posting was to the Snapchat. That's not part of the record. I think arguably if it's all within a minute, send,
Yeah.
it is part and parcel of the same act. But I was thinking of, well, I'm sorry, Aaron, I lost track of my thinking, but
Me all the time.
but if you go to Smith, and then I'm going to mispronounce it, Milky, which is an appeals court decision issued after Smith. In that case, you have one continuous act. I think in Smith, the evidence in reading the briefs, the evidence was maybe it was within a minute that there was a passing by, a parking, and then a driving back again. So there is a relatively short time frame there. I think arguably if we had more evidence, you could still make the argument, even if it were 3 social media platforms, if it's in a close period of time, it's one continuous act. I think it's hard to make that rule from this case, but you could make the argument.
And it's only acts of publication that count, you're saying?
It's the publication, it's the sending the information out into the world that is directed at the recipient. Until it's publicized, there is no communication. As the Chief Justice suggested, he could have written the song, he could have recorded the song, and he could have never let anyone hear it. And in that case, there would be no act to support a criminal harassment order.
Okay.
Thank you.
Hear ye, hear ye, hear ye. All persons having anything further to do before the Honorable Justice of the Supreme Judicial Court, now sitting in Boston, consider for the Commonwealth. At present depart, and give your attention tomorrow morning at 9 a.m., to which time and place the sitting of this court is now adjourned. God save the Commonwealth of Massachusetts.